General principles. International law defined. Traditional, that branch of public law which regulates the relations of states and of other entities which have been granted international personality. This definition focuses on subjects, which are entities which possesses international personality, and with rights and obligations recognized under international law, as against objects, which are persons or things in respect of which rights are held and obligations assumed by the subjects of international law. Number 2. Modern. The law that deals with the conduct of states and international organizations, their relations with each other, and in certain circumstances, their relations with persons, natural or juridical. American Third Restatement. Letter B. Basis of international law. Number 1. The law on nature's school. There is a natural and universal principle of right and wrong, independent of mutual intercourse or compact, which can be discovered and recognized by every individual through the use of his reason and conscience. Since individuals compose the state, whose will is but the collective will of the inhabitants, the state also becomes bound by the law of nature. Number 2. The Positivist School. The binding force of international law is derived from the agreement of the states to be bound by it. In this context, international law is not a law of subordination but of coordination. Number 3. The Eclectic or Grotian School. And so far as it conforms to the dictates of right reason, the voluntary law may be said to blend with the natural law and be indeed an expression of it. In case of conflict, the natural law prevails, being the more fundamental law. Public international law distinguished from 1. Private international law. As to nature, international versus municipal. As to remedies, international modes versus local tribunals. As to parties, international entities versus private persons. As to enforcement, international sanctions versus sheriff or police. Number 2. International morality or ethics. Principles which govern relations of states from the standpoint of conscience, morality, justice, and humanity. Number 3. International comity. Rules of politeness or courtesy observed by states in their relations with other states. Number 4. International diplomacy. Objects of international policy and the conduct of foreign affairs. Number 5. International administrative law. Body of laws which regulate the relations and activities of national and international agencies with respect to their material and intellectual interests which have received international recognition. International law as true law. Although it may not comply with John Austin's concept of law enforced by sovereign political authority, nonetheless, it is still true law. 1. Application, enforcement, and compliance. The absence of a central law-making authority and the debilitating jurisdictional defects weaken the expectation of compliance in comparison with the situation in the domestic plane. These considerations are, however, balanced by the risk of political or economic retaliation and other sanctions, such as adverse public opinion, retortions, reprisals, and UN machinery. The conviction that obedience will redound to the public good. Relationship with municipal law. Monist versus dualist. To monists, there is no substantial distinction between international law and municipal law, but to dualists, the distinctions lie in that municipal law is issued by a political superior for observance by those under its authority, while international law is not imposed but adopted by states as a common rule of action. Municipal law consists of enactments of the law-making authority, while international law is derived from such sources as international customs, conventions, or general principles of law. Municipal law regulates relations of individuals among themselves, while international law applies to relations between states and international persons. Violations of municipal law are redressed through local judicial and administrative processes, while in international law they are resolved through state-to-state transactions, and breaches of municipal law entail individual responsibility, while in international law there is collective responsibility. Number 2. Incorporation versus transformation. Letter A. The doctrine of incorporation is expressed in Section 2, Article 2, Philippine Constitution as follows. The Philippines renounces war as an instrument of national policy, adopts the general accepted principle of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. See Kuroda versus Jalandone, 83 Phil 171. Although the Philippines was not a signatory of the Hague and Geneva Conventions, international jurisprudence is automatically incorporated in Philippine law, thus making war crimes punishable in the Philippines. Loching versus Archbishop of Manila, 81 Phil 601. Borowski versus Commissioner of Immigration, where prolonged detention of a stateless alien pending deportation was deemed illegal, citing the Universal Declaration of Human Rights, which is incorporated in Philippine law. Letter B. Doctrine of transformation requires the enactment by the legislative body of such international law principles as are sought to be part of the municipal law. See Laguna Lake Development Authority versus Court of Appeals, where it was declared that Section 6, Article 2, Philippine Constitution, which reads, "The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature," which is taken from the Universal Declaration of Human Rights and the Alma Conference Declaration of 1978, recognizing health as a fundamental human right. Thus, the authority of LLDA to issue a cease and desist order to prevent the pollution of Marilao River was upheld on the basis of the principle of necessary implication. Number 3. Conflict between international law and municipal law. Letter A. On the domestic sphere, with the local court deciding. If the conflict is with the Constitution, uphold the Constitution. Section 5, Number 2, Letter A, Article 8, Philippine Constitution, which provides that the Supreme Court has the power to declare a treaty or executive agreement unconstitutional, and Secretary of Justice versus Judge Lantion, GR 139465, January 18, 2000, it was held that in states where the Constitution is the highest law of the land, such as the Republic of the Philippines, both statutes and treaties may be invalidated if they are in conflict with the Constitution. If the conflict is with a statute, the doctrine of incorporation as applied in most countries decrees that rules of international law are given equal standing with, but are not superior to, national legislative enactments. A treaty may repeal a statute, and a statute may repeal a treaty. Thus, the principle of lex posterior derogat priori, that which comes last in time, will usually be upheld by a municipal tribunal. See also Inchern versus Hernandez, where it was held that the retail trade nationalization law prevails over the Treaty of Amity with China and the Universal Declaration of Human Rights, because the law was passed in the exercise of the police power of the state, and police power cannot be bargained away through the medium of a treaty or a contract. Letter B. On the international sphere, with an international tribunal deciding international law is superior to municipal law, because international law provides the standard by which to determine the legality of a state's conduct. Letter F. Sources of international law. On the domestic sphere, the Constitution, legislative enactments, and case law, stare decisis. On the international plane, it is a bit complicated because there is no body likened to a national legislature, no fundamental law, and the doctrine of precedence is not applicable. Number 1. However, the most authoritative enumeration is found in Article 38, Statute of the International Court of Justice, which provides that the court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply. As primary sources, letter A, international treaties and conventions, whether general or particular, establishing rules expressly recognized by the contesting states. Letter B, international customs as evidence as a general practice accepted as binding law through persistent usage over a long period of time. Example, Angry exemption of an armed fishing vessel from capture. It is necessary, however, that the custom be 1. Prevailing practice by a number of states, 2. Repeated over a considerable period of time, 3. Attended by opinion juries, or a sense of legal obligation. Letter C. General principles of law. These are rules derived mainly from natural law, observed and recognized by civilized nations, like res judicata, prescription, pacta sunt servanda, and estopa. See Augustine versus Edu, where the doctrine of pacta sunt servanda was applied by the court relative to the validity of the administrative rule requiring the use of early warning device as part of the Vienna Convention on road signs and signals. Note, to these may be added the principle of ex eque et bono, what is good and just, provided that the parties to the dispute agree thereto, as provided in Article 38, Number 1, Statute of the International Court of Justice. As secondary sources, A. Judicial decisions, generally of international tribunals, the most authoritative being the International Court of Justice. They are not really sources, but subsidiary means for finding what the law is, and whether a norm has been accepted as a rule of international law. The decision of a national court may be used depending upon the prestige and perceived impartiality of the domestic court, not being in conflict with the decisions of international tribunals, and its admissibility in the form where it is cited. Letter B. Writings of publicists, which must be fair and unbiased representation of international law by acknowledged authorities in the field. Number 2. Interpretation of Article 38. Although the provision is silent on the question of whether the three primary sources have the same hierarchic value, by practice, treaties take precedence over customs and customs over general principles of law, except A. The principle of jus cogens, customary international law, which has the status of a peremptory, absolute, uncompromising, certain norm of international law. A peremptory norm is a norm accepted and recognized by the international community of states as a rule, from which no derogation is permitted and which can be modified only by a subsequent norm having the same character. Examples are slave trade, piracy, and terrorism. See Human Rights Cases versus Marcus, where it was held that official torture of prisoners, dissenters, was a violation of the principle of jus cogens. Subjects of international law. Distinction between subject and object of international law. Number 1. Subjects and objects of international law. A subject is an entity that has rights and responsibilities under international law. It can be a proper party in transactions involving the application of the law of nations among members of the international community. An object is a person or thing in respect of which rights are held and obligations assumed by the subject. It is not directly governed by the rules of international law. Its rights are received and its responsibilities imposed indirectly through the instrumentality of an international agency. Number two, the subjects of international law are states, colonies, and dependencies, mandates, and trust territories, the Holy See, Vatican City, the United Nations, belligerent communities, international administrative bodies, and to a certain extent, individuals. States, defined. A state is a group of people living together in a fixed territory, organized for political ends, under an independent government, and capable of entering into international relations with other states. Elements: a people, a group of individuals of both sexes living together as a community. They must be sufficient in number to maintain and perpetuate themselves. A casual gathering, stranded, or society of pirates would not constitute a state. B. Territory, a fixed portion on the earth's surface occupied by the inhabitants. It may be as large as China or as small as Monaco, 1/2 square meter mile, or San Marino, 38 square meter miles. Letter C. Government must be organized, exercising control over and capable of maintaining law and order within the territory. It can be held internationally responsible for the acts of the inhabitants. The identity of the state is not affected by changes in government. Letter D. Independence or sovereignty, freedom from outside control in the conduct of its foreign and internal affairs. Number 3. Other suggested elements of a state are: A. Civilization. B. Recognition. Recognition, the act by which a state acknowledges the existence of another state, a government, or a belligerent community, and indicates its willingness to deal with the entity as such under international law. Note: the importance of recognition has been substituted to a large extent by the Act of Admission of the United Nations. UN members must treat the new member as an equal partner in all matters relating to the application of the UN Charter. However, recall that the UN General Assembly refused recognition to Transkei, South Africa, and the UN Security Council called upon all states not to recognize Southern Rhodesia. Theories on recognition. Constitutive minority view. Recognition is the act which constitutes the entity into an international person. Under this view, recognition is compulsory and legal. It may be compelled once the elements of a state are established. Letter B. Declarative or majority view. Under the majority view, recognition merely affirms an existing fact, like the possession by the state of the essential elements. It is discretionary and political. Basic rules on recognition. It is a political act and mainly a matter of policy on the part of each state. It is discretionary on the part of the recognizing authority, and it is exercised by the political executive department of the state. Thus, the legality and wisdom of recognition is not subject to judicial review. Requirements for recognition of government. The government is stable and effective, with no substantial resistance to its authority. The government must show willingness and ability to discharge its international obligations, and the government must enjoy popular consent or approval of the people. Tobar, or Wilson Doctrine, precludes recognition of any government established by revolutionary means until constitutional reorganization by free election of representatives. Stimson Doctrine, no recognition of a government established through external aggression. Estrada Doctrine, since recognition has been construed as approval and non-recognition disapproval of a government established through a political upheaval, a state may not issue a declaration giving recognition to such government, but merely accept whatever government is in effective control without raising the issue of recognition. Dealing or not dealing with the government is not a judgment on the legitimacy of the said government. No, recall the recognition of the People's Republic of China based on the One China policy. Kinds of recognition may be expressed or implied, may also be de facto, extended by the recognizing state, which believes that some of the requirements for recognition are absent. The recognition is generally provisional and limited to certain juridical relations. It does not bring about full diplomatic intercourse and does not give title to assets of the state held or situated abroad. De jure, extended to a government fulfilling the requirements for recognition. When there is no specific indication, recognition is generally considered as de jure. The recognition is relatively permanent, brings about full diplomatic intercourse and observance of diplomatic immunities, and confers title to assets abroad. See Lawyers League for a Better Philippines versus Corazon Aquino, May 22, 86. Effects of recognition, diplomatic relations, right to sue in the course of the recognizing state. See Banco Nacional de Cuba versus Sabatino, where unfriendly relations or the lack of reciprocity was held immaterial. Immunity from jurisdiction, entitlement to property within the recognizing state, retroactive validation of the acts of the recognized states, government, such as acts of state, and thus sovereign immunity covers past, present, and future acts. Oit Gen versus Central Leather. Recognition of belligerency conditions. The usual conditions for the recognition of the status of belligerency are organized civil government having control and supervision over the armed struggle, serious and widespread struggle with the outcome uncertain, occupation of a substantial portion of the national territory, and willingness on the part of the rebels to observe the rules, customs of war. Note 1. Absence of any of the foregoing conditions will result merely in insurgency, which is rarely recognized. Number 2. Recognition may be either expressed or implied. The proclamation by the parent state of a blockade of a port held by the rebels is implied recognition of belligerency. So is the proclamation of neutrality by a third state. Effects of recognition of belligerency. Responsibility for acts of rebels resulting in injury to nationals or the recognizing state shall be shifted to the rebel government. The legitimate government recognizing the rebels shall observe the laws of war in conducting hostilities. Third states recognizing the belligerency shall maintain neutrality, and recognition is only provisional for the duration of the armed struggle and only for the purpose of the hostilities. Number 4. Creation of states by revolution, unification, cessation, assertion of independence, agreement, and attainment of civilization. Number 5. Extinction of states by extinction or immigration in mass of its population, loss of territory, overthrow of government resulting in anarchy. Principle of state continuity. The state continues as a juristic being, notwithstanding changes in its circumstances, provided only that such changes do not result in the loss of any of its essential elements. See Sapphire case, where after Emperor Louis, Napoleon filed a damage suit on behalf of France in an American court, he was deposed. Nonetheless, the action was not abated and could continue upon recognition of the duly authorized representative of the new government of France. Succession of states may be universal or partial. Consequences are political laws are abrogated, people versus prefecto, while municipal laws remain in force, Villas versus City of Manila. Treaties are discontinued, except those dealing with local rights and duties, such as those establishing easements and servitudes. All rights of the predecessor state are inherited, but successor state can assume and reject liabilities at its discretion. Note: in Haile Selassie versus Cable Wireless, it was ruled that a conquered state has no personality in international law. Succession of governments. The integrity of the state is not affected. The state continues as the same international person, except that its lawful representative is changed. The consequences are all rights of the predecessor government are inherited by the successor, and where the new government was organized by virtue of constitutional reform duly ratified in a plebiscite, all obligations of the predecessor are likewise assumed. However, where the new government is established through violence, the new government may lawfully reject purely personal or political obligations of the predecessor, but not those obligations contracted by it in the ordinary course of official business. Classes of states. Independent has freedom to direct and control foreign relations without restraint from other states, may be simple, single central government with power over international and external affairs. Composite, two or more sovereign states join together to constitute one international person, which may be real union. Two or more states are merged under a unified authority so that they form a single international person through which they act as one entity. The states retain their separate identities, but their respective international personalities are extinguished and blended in the new international person, like the former United Arab Republic with Egypt and Syria. Federal Union, combination of two or more states, which upon merger cease to be states, resulting in the creation of a new state with full international personality to represent them in their external relations as well as a certain degree of power over their domestic affairs and their inhabitants. Authority over internal affairs divided between federal authorities and the member states. Authority over external affairs handled solely by federal authorities. Be dependent, an entity which, although theoretically a state, does not have full freedom in the direction of its external affairs, such as a protectorate, which is established at the request of the weaker state for the protection by a strong power, example, Panama, Andorra, Monaco. Or suzerainty, which is the result of a concession from a state to former colony that is allowed to be independent subject to the retention by the former sovereign of certain powers over the external affairs of the latter. Example, Bulgaria and Romania, both suzerainties of the Sultan of Turkey by virtue of the Treaty of Berlin of 1878. Neutralized, whose independence and integrity are guaranteed by an international treaty on the condition that such state obligates itself never to take up arms against any other state except in self-defense, or to enter into an international obligation as would indirectly involve it in war. Example, Switzerland, Austria. The Vatican City and the Holy See. The Holy See has the constituent elements of statehood, people less than 1,000 individuals, territory 108.7 acres, government with the Pope as head, and independence by virtue of the Lateran Treaty of February 11, 1929, which constituted the Vatican as a territory under the sovereignty of the Holy See. It has all the rights of a state, including diplomatic intercourse, immunity from foreign jurisdiction, etc. See Holy See versus Del Rosario, where the Supreme Court distinguished Vatican City from the Holy See. The Holy See is an international person with which the Philippines had diplomatic ties since 1957. Letter D. Colonies and dependencies. A colony as a dependent political community consisting of a number of citizens of the same country who have migrated therefrom to inhabit another country, but remain subject to the mother state. A dependency is a territory distinct from the country in which the supreme sovereign power resides, but belongs rightfully to it, and subject to the laws and regulations which the sovereign may prescribe. Note: Theoretically, they belong to the parent state and thus are without any personality in the international community. However, on occasions, colonies have been allowed to participate in their own right in certain international undertakings. The Philippines was admitted as a signatory to the UN Charter. Letter E. Territories under international control or supervision. These are non-self-governing territories which have been placed under international supervision or control to ensure their political, economic, social, and educational advancement. An example are mandates, which were former territorial possessions of the states, defeated in World War I and placed under the control of the League of Nations. Many of these mandates became trust territories placed under the Trusteeship Council of the United Nations. A condominium is a territory jointly administered by two states. The United Nations. 1. Historical development of the United Nations. 8. The League of Nations, considered to have failed in attaining its primary objective of maintaining international peace and order, especially after the outbreak of World War II. Letter B. The London Declaration, June 12, 1941. Letter C. The Atlantic Charter, August 14, 1941. Letter D. Declaration of United Nations, January 1, 1942. Letter E. Moscow Declaration, October 30, 1943. F. Dumbarton Oaks Proposal, Washington, August to October 1944. Yalta Conference, Crimea, February 11, 1945. San Francisco Conference, April 25 to June 28, 1945, at which delegates from 50 nations unanimously approved the United Nations Charter, which came into force on October 24, 1945. On April 8, 1993, the UN General Assembly welcomed Macedonia, its 184th member, into the community of nations. Number 2. The UN Charter. This is the closest to a constitution that basically governs the relations of international persons. Technically, it is a treaty, a contract which the parties must respect under the doctrine of pacta sunt servanda, although it actually applies even to non-member states, at least insofar as may be necessary for the maintenance of international peace and security. It consists of 111 articles, besides the preamble and the concluding provisions. Annexed to it is the Statute of the International Court of Justice. Amendment 1. By vote of two-thirds of the members of the General Assembly and ratified in accordance with the respective constitutional processes by two-thirds of the members of the United Nations, including all the permanent members of the Security Council. Number 2. A General Conference called by a majority vote of the General Assembly and any 9 members of the Security Council may propose amendments by a two-thirds vote of the conference, and shall take effect when ratified by two-thirds of the members of the UN, including the permanent members of the Security Council. Purposes. The principal objectives of the UN are the prevention of war, the maintenance of international peace and security, the development of friendly relations among the members of the International Committee, the attainment of international cooperation and harmony in the actions of nations. Membership. Classes. Based on the manner of admission, members may be original or elective. Qualifications. Member must be a state, peace-loving, accept their obligation under the Charter, and be able and willing to carry out these obligations. Admission. Decision of two-thirds of those present and voting in the General Assembly upon recommendation of at least 9, including all the permanent members of the Security Council. Suspension. The same vote required as in admission. When suspended, a member cannot participate in meetings of the General Assembly, cannot be elected to or continue to serve in the Security Council, the Economic and Social Council, the Trusteeship Council, but nationals may continue serving in the Secretariat in the International Court of Justice, although a member is still subject to discharge its obligations under the Charter. To lift the suspension, a qualified majority vote of the Security Council is needed. Expulsion. Two-thirds vote of those present and voting in the General Assembly, upon recommendation of a qualified majority of the Security Council, on grounds of persistently violating the principles contained in the Charter. Withdrawal. It was intended that no provision on withdrawal be included in the Charter, although there is actually no compulsion for continued membership if the member feels constrained to withdraw due to exceptional circumstances. On March 1, 1965, Indonesia tried to withdraw in protest over Malaysia's election as member of the Security Council, but it appeared later that it was merely a cessation of cooperation, not withdrawal, and the UN allowed resumption of full membership of Indonesia on September 28, 1966. Organs. General Assembly consists of all the members of the organization, each of which is entitled to send not more than 5 representatives and 5 alternates. Each member has only one vote. Its functions may be classified into 1. Deliberative, like initiating studies and making recommendations for the development of international law, etc. Number 2. Supervisory, such as receiving and considering annual and special reports from other organs of the UN. 3. Financial, as a consideration and approval of the budget of the organization, the apportionment of expenses, etc. 4. Elective, as in the election of non-permanent members of the Security Council, all members of the ECOSOC, etc. And 5. Constituent, such as the admission of members in the amendment of the Charter. Its regular session is held once a year, and it may hold special sessions called by the Secretary General at the request of the Security Council or a majority of the members. On important questions, example, peace, security, membership, elections, trusteeship system, budget, the vote of 2/3 of the members present and voting is required. On other questions, a simple majority is sufficient. To clarify a question as important, the vote required is a simple majority. Security Council. It is the key organ in the maintenance of international peace and security. It is composed of 5 permanent members, namely China, France, Russia, the United Kingdom, and the United States, and 10 elected members, elected for 2-year terms by the General Assembly, 5 from African and Asian states, 2 from Latin American states, 2 from Western European and other states, and 1 from Eastern European states. For the elective members, no immediate re-election is allowed. The Security Council is expected to function continuously, and sessions may be called at any time. Thus, the representative of the member states should always be available. Functions. The Security Council has primary responsibility to maintain international peace and security, investigate disputes and call disputants to settle their differences through peaceful means, recommend methods of adjustment of disputes, determine the existence of threats to peace, breach of peace, acts of aggression, and make appropriate recommendations, and to undertake preventive and enforcement actions. Preventive action shall consist of provisional measures to prevent a conflict from worsening and may involve the deployment of peacekeeping and/or observer missions. These missions shall be established by the Security Council, directed by the Secretary General, with the consent of the host government, provided that the military observers shall be unarmed, while peacekeeping forces may be armed with light weapons, although they are not authorized to use force except in self-defense, and the operations must not interfere with the internal affairs of the host country. Other measures may also be undertaken against erring members, such as interruption of economic relations, communications, or diplomatic relations. Example, the ban, except for humanitarian reasons, or air flights for Libya because of the bombing of Pan Am Flight 103. Enforcement action may consist in the deployment of air, sea, and land forces, or in the institution of a blockade. Enforcement actions in the past had been usually stymied by the veto power of the permanent members of the Security Council. Domestic Jurisdiction Clause. The Security Council may take such steps as are necessary for the settlement of dispute, including preventive or enforcement action, as mentioned above. The only limitation is that the dispute must be international, not domestic in character. Otherwise, such action would violate the principle that the UN shall not intervene in any matter within the domestic jurisdiction of any state. Voting. The Yalta Formula. Each member of the Security Council shall have one vote, but distinction is made between the permanent members and the non-permanent members in the resolution of substantive questions. Procedural matters are to be decided by the affirmative vote of any 9 or more members. Non-procedural matters are decided by the concurrence of at least 9 members, including all the permanent members. The determination of whether a matter is procedural or substantive is non-procedural. This allows for the so-called double veto by a permanent member of the Council. However, the abstention or absence of any permanent member is not considered a veto. Economic and Social Council, composed of 54 members elected by the General Assembly for a 3-year term. It shall exert efforts toward higher standards of living, conditions of economic and social progress and development, solutions of international economic, social health and related problems, universal respect for and observance of human rights and fundamental freedoms. Decisions are reached by a simple majority vote. Trusteeship Council, charged with the duty of assisting the Security Council and the General Assembly in the administration of the international trusteeship system. It is composed of 1. Members of the UN administering trust territories. 2. Permanent members of the Security Council not administering trust territories. And 3. As many other members elected by the General Assembly as may be necessary to ensure that the total number of members is equally divided between those members of the UN which administer trust territories and those which do not. Note that the last trust territory, Micronesia, has since then become an independent state. Secretariat, the chief administrative organ of the UN, headed by the Secretary General, who is chosen by the General Assembly upon recommendation of the Security Council. The Secretary General is the highest representative of the UN and is authorized to act in its behalf. He also acts as Secretary in all meetings of the General Assembly. The Security Council, the Economic and the Social Council, and the Trusteeship Council. The Secretary General and his staff are international civil servants, and they cannot receive instructions from any government or source outside the UN. The Secretary General enjoys the right of political initiative and may bring to the attention of the UN Security Council any matter which, in his opinion, may threaten international peace and security. International Court of Justice. It is the principal judicial organ of the UN, composed of 50 members who are elected for a term of 9 years by absolute majority vote in the General Assembly, and the Security Council is separate elections. No 2 of whom must be nationals of the same state. They must be of high moral character and possess the qualifications required in their respective countries for appointment to their highest judicial offices. The court decides contentious cases and renders advisory opinions. Only states, including non-members of the UN, may be parties in contentious cases. The jurisdiction of the court is based on the consent of the parties in accordance with the optional jurisdiction clause, and the court may decide on interpretation of treaties, in the question of international law, the existence of facts constituting breach of international obligations, and the nature or extent of the reparation to be made for the breach of an international obligation. Advisory opinions may be given upon request of the General Assembly or the Security Council or the other organs of the UN when authorized by the General Assembly. International administrative bodies. Certain administrative bodies created by agreement among states may be vested with international personality, provided that they are non-political and are autonomous and not subject to control by any state. Example: ILO, FAO, WHO. 1. International Law Commission. This was established by the UN General Assembly in 1947 to promote the codification and progressive development of international law. One of the functions of the Commission is to produce draft articles which may codify certain customary international law or aid its development. Among these, of great significance is the draft articles of state responsibility, which are often considered as embodying generally customary international law on the matter. Number 2. Legality of the threat or use of nuclear weapons. Opinion. WHO. Case ICJ 1996-66. The International Court of Justice ruled that it did not have jurisdiction to decide on the request of the World Health Organization to the former to render an advisory opinion on whether the use of nuclear weapons by a state in war or other armed conflict would be a breach of its obligation under international law, including the W Convention. Unlike states, which possesses general competence, international organizations are governed by the principle of specialty. That is, they are invested by the states which create them with powers, the limits of which are a function of the common interest whose promotion those states entrust to them. In the opinion of the International Court of Justice, to ascribe to WHO the competence to address the legality of the use of nuclear weapons would be tantamount to disregarding the principle of specialty, for such competence could not be deemed necessary implication of the Constitution of WHO in light of the purposes assigned to it by the member states. Individuals. Although traditionally individuals have been considered merely as objects, not subjects, of international law, they have also been granted a certain degree of international personality under a number of international agreements, some of which are: A. UN Charter provisions on faith in fundamental human rights, dignity and worth of the human person, and in the equal rights of men and women. Letter B. Universal Declaration of Human Rights provision on the inherent dignity and the equal and inalienable rights of all members of the human family. Letter C. Some treaties. Example: the Treaty of Versailles, which conferred on individuals the right to bring suit against states before national or international tribunals. D. The need for states to maintain an international standard of justice in the treatment of aliens. Letter E. The Genocide Convention, which condemns the mass extermination of national, ethnic, racial, or religious groups. F. The 1930 Hague Convention, which is rules to prevent the anomalous condition of statelessness, and the 1954 Covenant relating to the status of stateless persons, which grants stateless individuals certain basic rights, and G. The 1950 European Convention on Human Rights and Fundamental Freedoms, which grants private associations and individuals the right to file complaints before the European Court on Human Rights.